Hello, this is Sophie Hammond and your Patton University online course instructor for this semester. We are in course FIN610, Risk Analysis and Insurance, and today we're going to be going over Unit 6, Job-Related Benefits, beginning with the introduction and overview. This unit will examine two compulsory programs, workers' compensation and unemployment compensation. Workers' compensation is a system that requires employers to pay workers for their work-related injuries and illnesses with no relationship to who caused the injury or illness, even those caused by the employee. This program is funded by employers based upon the payroll distributed. There are 4 types of benefits provided, including medical, survivor's benefits, rehabilitation, and income replacement. From both a financial as well as moral standpoint, the overall goal of a firm is to decrease work-related injuries and illnesses by preventing accidents. To this end, employers put together sophisticated programs and incentives to decrease accidents within the workplace. Unemployment compensation programs pay weekly cash benefits to workers who are involuntarily unemployed. This program is funded by the Federal Unemployment Tax Act, FUTA or FUTA, which places a tax on employers at a rate of 6.2% of workers' pay in covered jobs. To help compensate for this burden, an experience rating was adopted which reduces the contribution of employers that have little unemployment. This encourages employers to reduce or at least stabilize unemployment as much as possible. As workers' compensation and unemployment compensation are both compulsory programs, understanding the programs and their benefits will enable employers to better facilitate the programs and give employees a means to ensure that they are receiving the correct benefits. There are 3 learning objectives for this unit. Number 1, describe workers' compensation laws. Number 2, to examine the complexity of workers' compensation benefits and issues. And number 3, to critique the components of unemployment compensation. So we will now be moving on to reading a good portion of Objective 1, which is to describe workers' compensation jobs. Beginning with the first and only reading, workers' compensation laws and benefits. Each state and certain other jurisdictions, such as the District of Columbia and other U.S. territories, has a workers' compensation system to enforce a series of state laws that requires employers to pay workers for their work-related injuries and illnesses with no relationship to who caused the injury or illness. History and purpose. In the 19th century, before implementation of workers' compensation laws in the United States, employees were seldom paid for work-related injuries. A major barrier to payment was that a worker had to prove an injury was the fault of his or her employer to recover damages. The typical employee was reluctant to sue his or her employer out of fear of losing the job. For the same reason, fellow workers typically refused to testify on behalf of an injured colleague about the circumstances surrounding an accident. If the injured employee could not prove fault, the employer had no responsibility. The injured employee's ability to recover damages was hindered further by the fact that even a negligent employer could use 3 common law defenses to disavow liability for workers' injuries: the fellow servant rule, the doctrine of assumption of risk, and the doctrine of contributory negligence. Under the fellow servant rule, an employee who was injured as a result of the conduct of a fellow worker could not recover damages from the employer. The assumption of risk doctrine provided that an employee who knew or should have known of unsafe conditions of employment assumed the risk by remaining on the job. Further, it was argued that the employee's compensation recognized the risk of the job. Therefore, he or she could not recover damages from the employer when injured because of such conditions. If an employee was injured through negligence of the employer but was partly at fault, the employee was guilty of contributory negligence. Any contributory negligence, regardless of how slight, relieved the employer of responsibility for the injury. These defenses made recovery of damages by injured employees nearly impossible and placed the cost of work-related injuries on the employee. As a result, during the latter part of the 19th century, various employers' liability were adopted to modify existing laws and improve the legal position of injured workers. The system of negligence liability was retained, however, and injured employees still had to prove that their employer was at fault to recover damages. Even with modifications, the negligence system proved costly to administer and inefficient in protecting employees from the financial burden of workplace injuries. The need for more extensive reform was recognized, with many European countries instituting social insurance programs during the latter half of the 1800s. Beginning with Wisconsin in 1911, U.S. jurisdictions developed the concept of workers' compensation that compensated workers without the requirement that employers' negligence must be proved, that is, with strict employer liability. Costs were borne directly by employers, generally in the form of workers' compensation insurance premiums, and indirectly by employees who accepted lower wages in exchange for benefits. To the extent, if any, that total labor costs were increased, consumers who benefited from industrialization shared in the burden of industrial accidents through higher prices for goods and services. Employees who demanded higher total compensation, wages plus benefits, to engage in high-risk occupations, resulting in incentives for employers to adopt safety programs. By 1948, each jurisdiction had similar laws. In compromising between the interests of employees and those employers, the originators of workers' compensation systems limited the benefits available to employees to some amount less than the full loss. They also made those benefits the sole recourse of the employee against the employer for work-related injuries. This give and take of rights and duties between employers and employees is termed quid pro quo, Latin for this or that. The intent was for the give and take to have an equal value on average. You will see in our discussion of current workers' compensation issues that some doubt exists as to whether equity has been maintained. An exception to the sole recourse concept exists in some states for the few employees who elect prior to injury not to be covered by workers' compensation. Such employees, upon injury, can sue their employer. However, the employer in these instances retains the three defenses described earlier. In addition to every state and territory having a workers' compensation law, there are federal laws applicable to longshore workers and harbor workers, to non-government workers in the District of Columbia, and to civilian employees for the federal government. Workers' compensation laws differ from jurisdiction to jurisdiction, but they all have the purpose of ensuring that injured workers and their dependents will receive benefits without question of fault. Coverage. Coverage under workers' compensation is either inclusive or exclusive. Further, it is a compulsory or elective depending on state law. A major feature is that only injuries and illnesses that arise out of and in the course of employment are covered. Inclusive or exclusive. Inclusive laws list all the types of employment that are covered under workers' compensation. Exclusive laws cover all the types of employment under workers' compensation except those that are excluded. Typically, domestic service and casual labor for some small jobs are excluded. Agricultural workers are excluded in 19 jurisdictions, whereas their coverage is compulsory in 27 jurisdictions and entirely voluntary in 4 jurisdictions. Some states limit coverage to occupations classified as hazardous. The laws of 39 states apply to all employers in the types of employment covered. Others apply only to employers with more than a specified number of employees. Any employer can comply voluntarily. Compulsory or elective. In all but 2 states, the laws regarding workers' compensation are compulsory. In these 2 states, New Jersey and Texas, with elective laws, either the employer or the employee can elect not to be covered under workers' compensation law. An employer who opts out loses the common law defenses discussed earlier. If the employer does not opt out, but an employee does, the employer retains those defenses as far as that the employee is concerned. If both opt out, the employer loses the defenses. It is unusual for employees to opt out because those who do must prove negligence in order to collect and must overcome the employer's defenses. An employer who does not opt out must pay benefits to injured employees in accordance with the requirements of the law, but that is the employer's sole responsibility. Thus, an employee who is covered by workers' compensation cannot sue his or her employer for damages because workers' compensation is the employee's sole remedy, also called exclusive remedy. In fact, workers' compensation is losing its status as the employee's sole remedy against the employer. Later in this chapter, we will discuss some of the current methods used by employees to negate the exclusive remedy rule. By coming under the law, the employer avoids the cost of litigation and the risk of having to pay a large judgment in the event an injured employee's suit for damages is successful. In Texas, 65% of employers opted to stay in the system despite the fact that workers' compensation is not mandatory. It is likely that as insurance rates rise, more companies will opt to stay out of the system. Nearly all employers that opt out reduce their likelihood of being sued by providing an alternative employee benefit plan that includes medical and disability income benefits as well as accidental death and dismemberment benefits for work-related injuries and illnesses. In addition, the employer purchases employer's liability insurance to cover the possibility of being sued by injured employees who are not satisfied with the alternative benefits. Proponents of an opt-out provision argue that competition from alternative coverage provides market discipline to lower workers' compensation insurance prices. Furthermore, greater exposure to common law liability suits may encourage workplace safety. Opponents see several drawbacks of opt-out provisions. Some employers may fail to provide medical benefits or may provide only modest benefits, resulting in cost shifting to their segments of society. The right of the employee to sue may be illusory because some employers may have few assets and no liability insurance. Employees may be reluctant to sue the employer, especially when the opportunity to return to work exists or if family members may be affected. Safety incentives may not be enhanced for employers with few assets at risk. Covered injuries. To limit benefits to situations in which a definite relationship exists between an employee's work and the injury, most laws provide coverage only for injuries arising out of and in the course of employment. This phrase describes two limitations. First, the injury must arise out of employment, meaning that the job environment was the cause. For example, the family of someone who has a relatively stress-free job but dies of cardiac arrest at work would have trouble proving the work connection and therefore would not be eligible for workers' compensation benefits. On the other hand, a police officer or firefighter who suffers a heart attack, even while not on duty, is presumed in many states to have suffered from work-related stress. The second limitation on coverage is that the injury must occur while in the course of employment. That is, the loss-causing event must take place while the employee is on the job in order to be covered by workers' compensation. An employee injured while engaged in horseplay, therefore, might not be eligible for workers' compensation because the injury did not occur while the employee was in the course of employment. Likewise, coverage does not apply while traveling, the normal commute between home and work. Along the same lines of reasoning, certain injuries generally are explicitly excluded, such as those caused by willful misconduct or deliberate failure to follow safety rules, those resulting from intoxication, and those that are self-inflicted. Subject to these limitations, all work-related injuries are covered, even if they are due to employee negligence. In addition, every state provides benefits for occupational disease, which is defined in terms such as an injury arising out of employment and due to causes and condition characteristics of and peculiar to the particular trade, occupation, process, or employment, and excluding all ordinary diseases to which the general public is exposed. Some states list particular diseases covered, whereas others simply follow general guidelines. Benefits. Workers' compensation laws provide for 4 types of benefits: medical, income replacement, survivor's benefits, and rehabilitation. The reading goes on to talk about medical, degree and length of disability, and income replacement, but we are now going to move into Objective 2, which is to examine the complexity of workers' compensation benefits and issues, beginning with the first reading, how benefits are provided. Workers' compensation laws hold the employer responsible for providing benefits to injured employees. Employees do not contribute directly to this cost. In most states, employers may insure with a private insurance company or qualify as self-insurers. In some states, state funds act as insurers. Following is a discussion of coverage through insurance programs and through the residual markets, part of insurance programs for difficult-to-insure employers, self-insurance, and state funds. Workers' compensation insurance. Employers' risks can be transferred to an insurer by purchasing a workers' compensation and employer's liability policy. Coverage. The workers' compensation and employer's liability policy has three parts. Under Part 1, workers' compensation, the insurer agrees to pay promptly when due all compensation and other benefits required of the insured by the workers' compensation law. The policy defines workers' compensation law as the law of any state designated in the declarations and specifically includes any occupational disease law of that state. The workers' compensation portion of the policy is directly for the benefit of employees covered by the law. The insurer assumes the obligations of the insured, that is, the employer, under the law and is bound by the terms of the law as well as the actions of the Workers' Compensation Commission or other governmental bodies having jurisdiction. Any changes in the workers' compensation law are automatically covered by the policy. 4 limitations or exclusions apply to Part 1. These limitations include any payments in excess of the benefits regularly required by workers' compensation statutes due to 1. Serious and willful misconduct by the insured, 2. The knowing employment of a person in violation of the law, 3. Failure to comply with health or safety laws or regulations, or 4. The discharge, coercion, or other discrimination against employees in violation of the workers' compensation law. In addition, the policy refers only to state laws and that of the District of Columbia. Thus, coverage under any of the federal programs requires special provisions. Part 2 of the Workers' Compensation Policy, Employer's Liability, protects against potential liabilities not within the scope of the workers' compensation law, yet arising out of employee injuries. The insurer agrees to pay damages for which the employer becomes legally obligated because of bodily injury by accident or disease, including death at any time resulting therefrom, by an employee of the insured arising out of and in the course of his employment by the insured either in operations in a state designated in the declarations or in operations necessary or incidental thereto. Examples of liability covered under Part 2 are those to employees excluded from the law, such as domestic and farm laborers. Part 2 might also be applicable if the injury is not considered work-related, even if it occurs on the job. Part 3 of the Workers' Compensation Policy provides other state insurance. Previously, this protection was available by endorsement. Part 1 applies only if the state imposing responsibility is listed in the declarations. To account for the case of an employee injured while working out of state who may be covered by the state's compensation law, the other state's insurance part of the workers' compensation policy allows the insured to list states, perhaps all, where the employees may have potential exposure. Coverage is extended to these named locals. Cost. Based on payroll. The premium for workers' compensation insurance typically is based on the payroll paid by the employer. A charge is made for each $100 of payroll for each classification of employee. This rate varies with the degree of hazard of the occupation. Large employers can elect to have experience rating, which takes a company's prior losses into account in determining its current rates. Factors affecting rate. The rate for workers' compensation insurance is influenced not only by the degree of hazard of the occupational classification, but also by the nature of the law and its administration, and of course by prior losses. If the benefits of the law are high, rates will tend to be high. If they are low, rates will tend to be low. Moreover, given any law, no matter its benefits level, its administration will affect premium rates. If those who administer the law are conservative in their evaluation of borderline cases, premium rates will be lower than in instances where administrators are less circumspect in parceling out employers' and insurers' money. Most laws provide that either the claimant or the insurer may appeal a decision of the administrative board in court on questions of law, but if both the board and the courts are inclined toward generosity, the effect is to increase workers' compensation costs. Workers' compensation may be a significant expense for the employer. Given any particular law and its administration, costs for the firm are influenced by the frequency and severity of injuries suffered by workers covered. The more injuries, the more workers will be receiving benefits. The more severe such injuries are, the longer such benefits must be paid. It is not unusual to find firms in hazardous industries having workers' compensation costs running from 10 to 30% of payroll. This can be a significant component of labor costs. Whatever their size, however, these costs are only part of the total cost of occupational injury and disease. The premium paid is the firm's direct cost, but indirect costs of industrial accidents such as lost time, spoiled materials, and impairment of worker morale can be just as significant. These costs can be reduced by loss prevention and reduction and by self-insuring the risk. Loss prevention and reduction. Most industrial accidents are caused by a combination of physical hazard and faulty behavior. Once an accident begins to occur, the ultimate severity is largely a matter of chance. Total loss costs are a function of accident frequency and severity as explained in prior chapters. Frequency is a better indicator of safety performance than severity because chance plays a greater part in determining the seriousness of an injury than it does in determining frequency. Accident prevention. The first consideration is to reduce frequency by preventing accidents. Safety must be part of your thinking, along with planning and supervising. Any safety program should be designed to accomplish two goals. 1. Reduce hazards to a minimum, and 2. Develop safe behavior in every employee. A safety engineer from the workers' compensation insurer or a consultant for the self-insured employer can give expert advice and help the program. He or she can identify hazards so they can be corrected. This involves plant inspection, job safety analysis, and accident investigation. The safety engineer can inspect the plant to observe housekeeping, machinery guarding, maintenance, and safety equipment. He or she can help the employer organize and implement a safety training program to develop employee awareness and safe practices. He or she can analyze job safety to determine safe work methods and can set job standards that promote safety. The insurer usually provides employers with accident report forms and instructions on accident investigation. This is essential because every accident demonstrates a hazardous condition or an unsafe practice, or both. The causes of accidents must be discovered so that the information can assist in future prevention efforts. Inspections, job safety analysis, and accident investigations that lead consistently to corrective action are the foundations of accident prevention. The box, should ergonomic standards be mandatory, discusses the issue of job safety in the area of posture and position in the workplace. Loss reduction. Accident frequency cannot be reduced to zero because not all losses can be prevented. After an employee has suffered an injury, however, action may reduce the loss. First, immediate medical attention may save a life. Moreover, recovery will be expedited. This is why many large plants have their own medical staff. It is also why an employer should provide first aid instruction for its employees. Second, the insurer, along with the employer, should manage the care of the injured worker, including referrals to low-cost, high-quality medical providers. Third, injured workers should take advantage of rehabilitation. Rehabilitation is not always successful, but experience has shown that remarkable progress is possible, especially if it is started soon enough after the injury. The effort is worthwhile from both the economic and humanitarian points of view. All of society benefits from such effort. The reading continues, but we will now be moving into Objective 3, Critique the components of unemployment compensation, beginning with the reading Unemployment Compensation. While workers' compensation is quasi-social private insurance of significant concern to its many stakeholders, unemployment compensation is a purely social insurance program. Because of the high risk associated with projecting future rates of unemployment and associated claims, private insurers are not willing to provide this type of insurance. Unemployment compensation programs pay weekly cash benefits to workers who are involuntarily unemployed. The following sections cover state laws, coverage, how benefits are financed, and administration of unemployment compensation. State laws. State unemployment compensation programs were established as a result of federal legislation. However, each state creates, finances, and administers its own law. Like workers' compensation, the law transfers to the employer at least part of the financial element of a risk faced by the employee. Unlike most workers' compensation programs, however, the firm's risk manager has no choice with regard to how the risk is handled. Neither private insurance nor self-insurance is permitted. Management can reduce the cost, however, by stabling the firm's employment and preventing payment of unjustified benefits. Employers subject to tax. The federal tax applies to firms that have one or more employees in each of 20 weeks during a calendar year, or firms that pay $1,500 or more in wages during any calendar quarter. As of January 1987, coverage was extended to agricultural employers that have 10 or more employees in each of 20 weeks during the year, or that pay $20,000 or more in wages during any calendar quarter. New provisions to include domestic and municipal employees, as well as employees of nonprofit organizations, have also been added. Coverage. The federal law established minimum standards for coverage and benefits. Unless state law meets the standards, no tax offset is permitted. Each state meets the standards, and in many cases they are exceeded. Today, all states cover state and local government employees, several cover farm workers, and a few cover domestic workers. About 97% of the civilian labor force is covered. In some cases, unemployment compensation is self-assured in pool, as is the cause with the unemployment compensation of employees of many Texas school districts that opted to use the pool administered by the Texas Association of School Boards. Unemployment compensation is designed to relieve workers in certain industries and occupations of part of the economic burden of temporary unemployment. Three aspects of benefit payments are important. Number 1, amount and duration. Number 2, qualifications for benefits. And number 3, disqualifications. Amount and duration. The amount of the weekly benefit payment a worker may receive through unemployment compensation varies accordingly to the benefit formula in the law of each state. Usually, the amount is about 1/2 of the worker's full-time weekly pay within specified limits. The maximum is low and is easily accessible on the website of your state unemployment compensation agency, usually a division of the Employment Commission. Some states provide an additional allowance for certain dependents of the unemployed worker. With the passage of the 1986 Tax Reform Act, all unemployment benefits became fully taxable to the recipient for federal income tax purposes. Most state laws have a waiting period, typically 1 week, between the time an unemployed worker files a claim for benefits and the time benefit payments begin. This is designed to place the burden of short-term temporary unemployment on the workers as well as to decrease the cost of the plan, thereby making possible greater coverage of more significant unemployment losses. In most states, the maximum number of weeks that benefits can be paid is 26. A federal state program of extended benefits may continue payments for another 13 weeks during periods of high unemployment, such as occurred in the early 1990s. In an economic emergency, federal funding may continue payments for another 26 weeks. Qualifications for benefits. To qualify for benefits, unemployed workers must fulfill certain conditions. They must first be involuntarily unemployed. Once they are involuntarily unemployed, they are required to register for work at a public employment office and file a claim for benefits. They must have been employed by a job covered by the state unemployment compensation law. They must have earned a specified amount of pay or worked for a specified length of time, or both. They must be able to work. This is important in order to be able to differentiate unemployment benefits from disability benefits, available for work, and willing to take a suitable job if it is offered to them. In most states, an unemployed worker who is sick and therefore unable to work is not entitled to unemployment compensation benefits. Some states permit payments to disabled workers under a separate disability program. Disqualifications. Unemployed workers may be disqualified from benefits even if they meet the qualifications described above. As noted above, most state laws disqualify those who quit voluntarily without good cause or who were discharged for just cause. Those who refuse to apply for or accept suitable work or are unemployed because of a work stoppage caused by a labor dispute may be disqualified. Other causes for disqualification are receiving pay from a former employer, receiving workers' compensation benefits, receiving Social Security benefits, or being deemed an independent contractor and therefore not an employee. The effect of disqualification varies from state to state. In some cases, it means that the unemployed worker receives no benefits until he or she has again qualified by being employed for a specified length of time in covered work. In other cases, disqualification results in an increase in the waiting period. Some states' laws not only increase the waiting period but also decrease the benefits. How benefits are financed. Non-contributory. Most unemployment compensation insurance is non-contributory. Employers pay all the costs in most states. The Federal Unemployment Tax Act, FUTA, places a tax on employers at a rate of 6.2% of workers' pay in covered jobs, excluding anything over $7,000 paid to a worker in a year for the purpose of financing unemployment compensation. Up to 5.4% can be offset by employers who pay a state tax or have been excused through experience rating. So, in effect, the federal tax may be only 0.8%. Revenue from this tax is deposited in the Federal Unemployment Trust Fund and credited to the state for the payment of benefits under its plan. Each state has its own trust fund. The remaining part of the federal tax goes into general federal revenues. Congress appropriates money for grants to the states for their administration of the program. If appropriations for this purpose are less than the federal share of the payroll tax, then the remainder of such revenue is put into a reserve fund for aid to the states in payment of benefits when state reserves are low. Experience rating. All states have experience rating. That is, they reduce the contribution of employers whose workers have little unemployment. The theory of this rating system is that it encourages employers to reduce unemployment and stabilize employment to the extent that they can. One other effect, however, is to make employers interested in disqualifying workers who apply for benefits because the benefits paid out of their account reflect their experience under the plan. This has led to considerable discussion of qualification standards and administration and to many hearings and disputes. Administration. The federal portion of the Unemployment Compensation Insurance Program is administered by the Employment and Training Administration in the Department of Labor. Every state has its own employment security agency. Some are independent, others are in the State Department of Labor, and some other state agency. Typically, the agency is also responsible for the administration of state employment search offices. There are more than 2,500 such offices in the United States where claims for benefits may be filed. Claimants apply for benefits and register for employment at the same time. The function of the office is to find employment for claimants or provide benefits. See the key takeaways and the 3 discussion questions. There are more resources for Unit 6, including a Unit 6 review. However, this concludes our brief read-through of Unit 6 Job-Related Benefits.